Yes, you can sit. You can call the case.
Caribbean Court of Appeal, appellate jurisdiction, an appeal from the Court of Appeal of Guyana. Hearing of special leave application in CCJ Appeal GYCV number 14 of 2019 between Chandroutie Persaud, Rafudeen Nizamudin, and Javen Nizamudin. Today's panel comprise Mr. Justice Witt, Madam Justice Rajnath Lee, and Mr. Justice Jamada. Please state your appearances for the court.
May it please your honors, I'm Jamla Ali. Mr. Chandroutie and I appear for the appellants intended, for the applicants intended appellants.
Thank you.
May it please your honors, I am Mohammed Adil Nandan, and I appear along with Anuradha Devla Singh, Javen Shadik, Manoj Narayan, and Rajendra Jaikudin for the respondent.
Yes, thank you. This is in principle an application for special leave. That's why we are not roped. Well,
I wouldn't want to do it.
so you're kind of overdressed, Mr. Rafudeen, but it doesn't matter. It's about the it's about the arguments that we will hear from you and from Mr. Nandan. But reading the papers in this case, I must confess that, and I have thought this many times, why are you making things so complicated in Guyana with two fora of appeal and then very interesting but complicated rules on when to go to which court? It's, one would have thought that with the new civil rules, things could have been made a little simpler so that we don't get cases caught in all these procedural problems.
Good morning.
It is what it is, and so...
Good morning, Your Honors.
Good morning, Mr. Rafudeen.
On an aside, Your Honor, I had the experience where they took away my razor coming into the country yesterday. I had it in my carry-on. It seems that maybe Your Honor suffered the same fate. Good morning, Your Honors. It's, as the court says, a very simple issue. Uncomplicated, really. We are back to have another consideration of Section 6.2 of our Court of Appeal Act. On this occasion, the consideration is, and the crux of it, is about whether or not the proceedings mean a summary proceeding within the Act and thereby would indicate where the appeal would lie. Your Honor, just briefly, it is not disputed that these proceedings were commenced by a fixed date application in Guyana. We refer to it as an FDA. It is not disputed that it is for a remedy under a statute, that is the Immovable Property Sale of Interest Act, Chapter 6001, which, Your Honor, in theory, under our rules by Part 8, could be instituted either by a fixed date application or a statement of claim. There are only two ways to commence proceedings under our CPR. One would be by a fixed date application, one would be by a statement of claim. If it is deemed to be things that are urgent and the facts are uncomplicated, then the preference is, the rules provide for you to come by a fixed date application.
Mr. Dathleen, just pause there for a moment, please, because in your opinion, is under 801(2)(a), A1, 2, and 3, sub Romans 1, 2, and 3, are those disjunctive?
801(2)(a).
Yeah, Roman 1, 2, 3.
Your Honor,
Because what you just said,
is either urgent, they're disjointed.
they are disjunctive.
That's
Alright.
respectfully.
Just
my-
clarifying it. Yeah.
Yes, Your Honor.
That's my view also, but the way you expressed it, I thought you may have been saying it must be urgent and et cetera, et cetera.
Oh, forgive me, Your
it's
Honor.
disjunctive.
I,
Yep.
I spoke poorly.
No, thank you.
Your Honor,
Mr. Dutton, that is a matter that is accepted in Guyana, that these
As-
are disjunctive.
as far as I am aware, Your Honor, yes. That has been the practice that has been adopted.
Thank you.
Your Honor, the FDA in this particular case was determined on its merits. That's not disputed. There was affidavit evidence from both sides, lots of it indeed. The decision of the High Court, and indeed the Court of Appeal, regrettably, is unavailable. But it's not disputed that essentially what the High Court judge took the position, essentially an application of the statute of frauds, a purported application, if I may be so bold, Your Honor, to say that what was being raised was a trust, it related to land, and it had not been in writing, and therefore it would be unenforceable, so the court could proceed. None of this is disputed from the proceedings. The submissions at paragraph 18, I believe, of my opponent's pleadings, he does say that there's a hearing and evidence was taken. It is common ground that in the High Court that the affidavits constituted the evidence upon which this was done. Now we get to the core.
Was there any cross-examination or not?
No, there wasn't. There was no request for cross-examination. The core, maybe this convenient starting point is in this court, Your Honor. AIC Battery, the Chung versus AIC Battery case, involved the consideration of what was meant by summary proceedings.
Can I stop you, Mr. Dutton, and for this I apologize. Just going back to what you said, that there was no cross-examination.
There was none.
What has been happening in Guyana since the new rules have come? If there were to be cross-examination, what is it? Is there a practice that has now, or a process that the judges now, for example, follow, that the judge would say, well, I'll deem this, started by a statement of claim, put in your pleadings? Is that what will happen?
Your Honor, I have only known of one instance that I have personally experienced where in a matter that was an FDA and there was brief cross-examination on the affidavit, it related to a certificate from a evaluator. And it was really to determine whether the evaluator had the capacity to make what he had submitted. That was not converted to an SOC. To be honest with the court, there was no dispute between the two sides that there should be, the court should be satisfied, the court wished to be satisfied and could be satisfied by brief examination of the person who had given the valuation, the gentleman who had given the valuation. I don't know that the practice appears to be that if the court is of the view that more investigation is required, that it would be converted to an SOC and proceed thereafter with pleadings, witness statements, and a trial.
But Mr. Dutton, would you agree that because a matter in which there are facts in dispute, that's why I asked you about the disjunctive.
Yes, Your Honor.
Suppose it is urgent and there are many facts in dispute. Because if it is disjunctive, then it may be urgent,
Yes, Your
but it
Honor.
may not meet the Part 2 requirements that there are no material facts in dispute. Right?
Yes, Your Honor.
So is it that you can have because conceivably you can have a heavily contested matter on facts?
And it's urgent
Of
to...
course.
Yes, Your Honor.
Would that be suitable for FDA?
Your Honor, it would be my humble submission that you can approach it by an FDA when the court is faced with the response as to the disputed facts. Then the process could go on.
No, but the originating party who commences the matter ought to know, are there requirements for pre-action protocols in Guyana? Are there any requirements that you have to write letters before action?
No, Your Honor.
No, all right, that's not there, right? Okay. But,
then you fall back on 8045.
5,
yeah.
proceeding commenced you convert it to a statement of claim.
The judge can do 3 things.
Yes.
He can dismiss it.
He can agree with it, or he can convert it to a statement of claim. So those are the 3.
It as well.
Yes, he can.
Is that happening in Guyana?
It has happened, Your Honor, where the judge is of the opinion that there is insufficient evidence to obtain the remedy. The judge has taken the position, there are a few instances of which I'm aware, the judge taking the position that if you have come to the court and you've not disclosed everything and you've not brought everything, then it really wouldn't be suitable to proceed by an SOC. That's been a view taken, not necessarily one that I have agreed with, since in one occasion I might have been the victim.
Is judge thinking akin to abuse of process, you think?
Well, Your Honor, I think in the particular instance that I'm aware of, the judge was of the views that you were aware that you needed to get all of your materials in, and you shouldn't do it. It was a matter that was filed 3 weeks after we had introduced the rules, so there was a little bit of absence of familiarity, admittedly, on that occasion. But, Your Honor, what seems to be the driving force, at least in the Guyana Court of Appeal, and in, perhaps even to some extent in the submissions of my friend on the other side, is that AIC Chung and AIC Battery, this court considered this issue of summary proceedings and concluded that it had no special meaning. That was following a decision from the Eastern Caribbean of Frederick. Both of those cases are before the court, but essentially said that our Order 12, out of which is called a specially endorsed writ in the old rules, was really a reflection of Order 14 in the rules of the Supreme Court in the United Kingdom. So you commenced proceedings, summary proceedings, where you felt that there was no defense. In Guyana, what was the requirement is you filed an affidavit of defense and you had to demonstrate to the court that there was a triable issue, meaning your defense held water, had some form of merit. Upon you satisfying the court of that, the court will then permit you to file a statement of defense and the matter proceeded normally. If you were unable to do that, the judge would strike out your defense and award judgment. Now,
So are you saying in Chung, that was the Order 12, it was an Order 12 application, which is
of the old rules.
which is the equivalent of a UK Order 14?
The UK Order 14. Well, Your Honor, the old UK Order 14 as well. The summary,
Yeah.
the summary judgment provision.
So that was what was at stake in Chung,
That was the issue that this court had decided.
in Chung.
In Chung. Yes, Your Honor. Now, in Chung, what had happened, it had been raised before by Justice of Appeal, Chang. Justice Chang was sitting in the Court of Appeal at the time, and he had raised it in Thomas and Thomas again. That was the first time that it had been raised, essentially, that where the judge strikes out your defense, it's in fact a summary proceeding, and therefore the appeal should lie to the full court. However, that Order 12 interpretation was made in relation to what summary proceedings made. That was what Chung was considering. The full length and breadth of Section 2A was being considered. And But to say, Your Honor, that the further submissions or the further interpretation, as might be found in the texts or might be found in case law in the United Kingdom, that summary proceedings meant it was a short trial or it was a trial without formalities or any of those interpretations, it would be difficult to justify. And this is why it would be. It cannot be doubted that every motion filed in the last 50 years, nearly every motion at least, filed in the last 50 years in Guyana, which was under the old rules, were determined by affidavit evidence. Every constitutional motion, the motions that have come to this court, Robin Singh and the Guyana Cricket Board, we recently, the last time I was here with the Christopher Ram and the series of matters, those were all FDAs, those were all affidavits. Not one bit of evidence was taken. All of those matters were appealed to the Court of Appeal, and subsequently we ended at Your Honor's doorstep.
You say not one bit of further oral evidence?
None.
I understand.
Now,
Those were not commenced by statement of claim.
no, they were commenced by FDAs.
So you were using, what you were doing, I suppose, was under the old RSC, constitutional motions, administrative actions, matters brought pursuant to legislation, those were brought by motion.
Yeah, indeed, Your Honor.
So you all were interpreting Part 8 to mean fix FDA to be as per the old motion.
Yes,
So you
Your
were
Honor.
continuing to bring constitutional motions, JR applications by motion, by affidavit, and
You-
they follow that course.
Your Honor, that is indeed the approach that has
That is the
taken place.
current practice.
Indeed, Your Honor.
Nobody's bringing constitutional motions or JR applications by statement of case.
None that I am aware of, Your Honor.
Yes.
None, at least none are reported.
Right, okay.
Even in the old system,
A short point would be those could not conceivably be summary proceedings. Is that what you're saying?
not as far as the Court of Appeal Act was concerned.
Why?
Because, Your Honor, the evidence was before the court, and if I may respectfully submit to the court, the governing factor was a determination on the merits. If there was some form of a defect, and I use that word loosely, I've spent more than one night trying to figure out another word to use, but if there was some sort of a defect, meaning you didn't file your papers, you didn't do something you were supposed to do, or you didn't, a judge exercised the discretion to abbreviate the process, it was those that were considered summary proceedings, but not where the proceedings actually proceeded on the basis of what was given and in the affidavits as evidence, and a determination was made on the merits. Now, it is not disputed in this particular case that there was a determination, all the affidavit evidence were accepted, the judge was of the view that it was a matter of law, and he made his ruling. So there was no issue. In most constitutional matters, respectfully, Your Honor, there's rarely a dispute as to what took place. The fight is usually whether it was a breach and whether or not there was an appropriate exercise of state authority. But all public law matters, if we take Robin Singh, which had come to, Robin Singh and the Guyana Cricket Board, which had come to this court, Your Honor, that was under the old prerogative writ procedures, where an application was made. I had made an application for an order nisi. That was refused. We had gone to the full court in those proceedings because it was thought that it was an ex parte proceeding and it was summary proceedings and we couldn't go to the Court of Appeal, and this court said, no, you need to go to the Court of Appeal. And the part about summary proceedings and the later of ex parte did not apply. But, Your Honor, that has also been the practice. If I may be so bold, Your Honor, respectfully, what has been happening is we might be taking the position that we are trying to take FDAs, fixed date applications, and equate them with specially endorsed writs under the old rules. But FDAs are much wider, and they can be used differently. But to say that the FDA is the equivalent of a summary judgment process for a summary process, Your Honor, would not be correct, respectfully. It would not meet those standards. Because if that were so, Your Honor, every constitutional motion, this court has dealt with several, including in the prerogative writ matter, where we were continuing, despite the introduction of the CPR, we were continuing with a practice of applying for an order nisi, and we had a Judicial Review Act, but there was no facility to file it. The registry didn't, and I think this court, in very strong terms, made it clear in the Ocampo Truba matter in the Medical Council that you had to give effect to the rules. They were a different system. And the same is true here. An FDA is not a specially endorsed writ, notwithstanding whatever has happened. My friends, on the other side.
So Dattadin, do you think though that FDAs have replaced the specially endorsed writ in certain cases?
Yes,
For example, under enactments, I'm not sure. Before,
Well-
how would you bring an action if you come in under a particular enactment in
Your Honor,
Guyana?
my respectful opinion to that would be that if you went through Part 8012, and you could not meet either urgent, either facts in dispute.
No
If you-
facts in dispute.
Yes,
yeah.
no facts, like here.
Right, so unless you could do that, even if they were under an enactment, respectfully, Your Honor, you'd have to come by an SOC.
But it seems to me that what they've done with the new rules is created two forms of originating proceeding.
Yes, Your Honor.
Everything, the general rule is you start by statement of case.
That is,
Yes, that's the general principle. The exceptions are what you call your FDAs, and depending on how we construe 8012, whether it is disjunctive or conjunctive,
Yes,
there's
sir.
either one category, which includes all four, which does not make sense, because then what you do, well, maybe it makes sense, or there are several categories. It is urgent, or no material facts in dispute, or it can be determined right away, even if there are facts in dispute. That's your C3, right?
yes, Your Honor.
It can be determined on the affidavit evidence in support, or the rules or practice direction or order required.
Yes, Your Honor.
And that cuts across the board.
Yes,
So
Your Honor.
no longer categories of statutory actions by originating summons, no longer
Indeed,
habeas
Your Honor.
corpus by petition, no longer JR or constit by motion.
Indeed, Your Honor.
So a constit could start by SOC,
If,
a statutory application could start by SOC.
yes, Your
You have
Honor.
to just look at the rules and see if you fit the criteria.
Well, Your Honor, it has been, at least initially, what happened when we introduced the rules, because the FDAs were supposed to be a quicker, or appeared to be a quicker process, that you'd get a hearing right away and you could be. There was a heavy influx of matters that were filed by FDA. And then there was a large amount of them, which of course had to be converted to SOCs because of unsuitabilities of different sorts. Some were struck. But, Your Honor, my respectful submission, Your Honor, is starting point has to be SOC, and then you are allowed a slightly different starting point if you meet certain criteria. But if you can't meet the criteria, then you have to file an SOC. And it would be,
But the issue before us is, where do we interject or interpose summary proceedings?
Your Honor,
Can you have a SOC that is a summary proceeding?
well,
You have a FDA that is a summary proceeding? Because Section 6 of the Court of Appeal Act says something very specific about summary proceedings.
Yes,
And the new CPR says nothing about summary proceedings.
nothing.
Right.
Your Honor, there are two.
Oh, the task at hand is to figure out.
What are summary proceedings?
Exactly.
Or better yet, for me, is this
Is this a
matter
summary?
before us?
Your Honor, if I may,
But we both pause for this reason because you see, if you're going down the road that an FDA can or cannot be, or SOC can or cannot be, the rules do not refer to summary proceedings. The only reason summary proceedings come in is because Section 6 of the Court of Appeal Act says, hold on, if it is a summary proceeding, you have to go to the full court. Correct?
yes, Your Honor.
So, as our sister has said, was this proceeding summary? And maybe something more general about what summary proceedings could be, but that's what this case is about.
Yes, Your Honor. Your Honor, if I may,
To be clear, there is no definition of summary proceeding
no, Your
in
Honor.
the Act nor in the rules.
No, Your Honor.
So that, that creates immediately a problem that shouldn't be there.
Yes, Your Honor.
Okay,
But
but it's there, so.
But Your Honor, if I may, to answer Justice Jamada, if I may just say as to whether or not summary proceedings under the rules, it is my respectful submission, Your Honor, that the Court of Appeal Act, when it existed, was designed or intended to deal with matters that came out of the High Court when there were certain rules that existed that fed the Court of Appeal. So the High Court feeds the Court of Appeal still. But we've changed the rules to remove the Order 12 scenario, for example. So the issue, the feeding of the matters into the Court of Appeal, which would have been issues under different rules, may not arise now, save and except if you have summary judgment. And I know that if you read the text in the dictionaries, that summary judgment is not the same thing as summary proceedings. But I do believe that where our act is concerned, that it's essentially equating the two, because that's all that could be left under our new CPR, where you...
Well, pause. You've just told us, and I think it's an important contextual question, or matter for consideration, that the Court of Appeal Act, when it existed, it predated the CPR.
Yes, Your Honor.
That's accepted. At that time, clearly there was a species of something called a summary proceeding.
Yes, the specially endorsed writs.
Well, before we decide what it is, part of our investigative task should be what were, in law, summary proceedings for the purposes of the Court of Appeal Act. So that the answer to that question would reveal what it is that the legislators intended, yes?
Yes, Your Honor.
When, in 62A1, they said that summary proceedings should go to the full court, because they had an intention then.
Your Honor, that's why when I'd said earlier, if respectfully, that summary proceedings would mean that there would be a matter where there was some sort of a defect.
But where is that to be found?
No, well, again, Your Honor, because what would happen essentially, for example, even under our new rules, there was a great distinction, and we used to be in this court over chambers, whether an order was made in chambers or open court. But under the new dispensation that exists with the CPR, that has become largely otiose. The proceedings are considered all to be being heard in open court, essentially, regardless of the physical place in which it is heard.
Yeah, but Mr. Dattelen, under the old rules, and I have them here, the High
Yes.
Court Act and the High Court rules,
Yes.
did not give an interpretation of a summary proceeding.
No, Your Honor.
So when you, at least I understood your saying that it was understood then that an Order 12 would be a summary proceeding. Is that what you're saying? And
Your
dispensation?
Your Honor, I would be bold to say it was my idea, but it was this court's idea in AIC Battery.
Yes, no, I thought you were speaking of some other
No, Your Honor.
interpretation besides.
No, that's the only interpretation that it is the most recent, the most, in terms of an apex court, in terms of a determination. That's been it. But Order 12 no longer exists. And the respectfully AIC Battery case was about what transpired when Order 12, the specially endorsed writ procedure, was engaged. So,
But do you agree, though, that the Order 12 served a similar purpose? For example, on a liquidated demand for money and so on?
as an FDA would, Your Honor, in some circumstances, indeed, as the court has said with liquidated demand. In fact, what has happened, what has just been filed by my friend is there is a practice direction, a recent practice direction that has been given as to matters that should be filed by FDA. It is indeed, if Your Honor has,
That's before this action was started? Before this current?
Your Honor, I can check date. No, Your Honor. But, Your Honor, it is, again, not without difficulty because it is, in fact, as the court will see, it is, in fact, a reproduction of most of the things and the words that were stated in Order 4, Rule 6. So, we had the rules that stated what were the things. We then had a practice direction of number 1 of 2018, October 2018, when this came into force. The action had already started. But, Your Honor, this reflects Order 4, Rule 6. Essentially.
When you say Order 4, Rule 6, you mean the old Order 4, Rule 6?
Yes, the Order 4, Rule 6.
Same liquidated demand.
Same liquidated demands on a contract, enforcing opposition, hire purchase. Those are the things which are now being said. But, Your Honor, whether this is, without belaboring the point, Your Honor, whether this is a practice direction or an amendment might be an issue that will reach.
But 8012 says, B, a proceeding must be commenced by a fixed date form if B, the rules, a practice direction on order so require it. So if a practice direction is passed saying that certain kinds of action should be brought by fixed date application, that is pursuant, one assumes, to 8012B.
Yes, Your Honor.
And it does not exclude the categories in 8012A.
Correct, Your Honor.
It now specifies certain categories pursuant to 8012B.
Yes, Your Honor. So essentially what has happened is Order 4, Rule 6 has returned in a different form, as it were. But respectfully, Your Honor, that wouldn't change because what used to happen under the old procedures is you had to file to disclose a defense. If you didn't disclose a triable issue and it was your defense, your affidavit of defense was struck out, then your appeal lay to the full court because those were considered summary proceedings. But the proceedings, that scenario of having something struck out, under the powers that exist under a case management conference and under the powers that the judges now have under the new civil procedure rules, they can exercise such powers to restrict and limit. And maybe those are going to be the only proceedings for which summary proceedings in the Court of Appeal Act would apply. But it couldn't apply respectfully to a matter that was determined on the merits. The rules provided for how it was to be determined, and it was determined in that way. So to apply what the text writers would provide as a definition would not or could not be done without great difficulty. It couldn't be justified because our practice of conducting proceedings on affidavit evidence alone and coming to a determination and taking the further determination of the issue directly to the Court of Appeal has been a practice that has been in Guyana for decades. All the constitutional, judicial, public law, everything, this court considered Nabi and Shir Mohammed, that was a company law issue, and that was commenced by a motion, a notice of motion. There was only evidence was from on affidavit. It proceeded. This court has considered a contempt motion that had been brought to this court in the first incarnation of the Blairmont matter. That was again something that was the origins were.
So that if neither the Court of Appeal Act nor the rules define summary proceedings, and if in the court structure, a summary proceeding, the appeal goes to the full court, yes?
Yes.
Right? How would you define summary proceedings? Not by categories. How would you define summary proceedings? Because the legislators intended it to have a meaning. It's been there in the Court of Appeal Act. No doubt the courts have been given effect to it because certain categories of matters have been going to the full court. Prior to the CPA?
Prior to the CPR, the only matters that went to the full court is matters that were made in chambers, which were interlocutory matters,
Right.
or matters in where the default judgment,
Order 14 would have gone.
Order 14,
Liquidated
default,
claims. If you're suing on a pro note for a liquidated sum,
yes, Your Honor.
that would have been brought on a specially endorsed writ,
Yes, Your Honor.
right? Would that not have gone? Because those are usually
If the affidavit of defense was struck out,
Yeah.
it would have gone.
to the full court.
Yes, if the affidavit of
How
defense,
would you try to define all those kinds of matters? And those are all matters in which summary proceedings have a certain meaning.
yes, Your Honor.
How would you say what that
Your Honor, I spent a lot of time looking for a word and I could only come up with proceedings of defect. I know it is wholly insufficient, but
it's not-
it was a matter where it was sort of curtailed, if we're to take a view like that, because what would happen in those proceedings essentially is the determination was not by all sides. One side clearly had nothing, and that's why I came up with the defect. So in proceedings which were like constitutional motions, for example, where both sides put in all their affidavits, and then a determination is really made on a matter of law, that's not a situation where there was a quote-unquote defect. I hope I don't have that word stick. I know there must be better than that. But it was, so, which is why, Your Honor, it would go down the road almost respectfully under the new CPR of essentially proceedings that would be considered under being a summary judgment, as what the rules provide for, summary judgment, default judgment. So essentially what the current CPR provides for, or in the instances, Your Honor, where even at an SOC, if a court were to exercise its discretion to strike out a matter before it got to a hearing, so that there wasn't a determination at the end. Because, Your Honor, if we're to look at it, even the way the CPR is, if I could respectfully suggest how I understand it, with the overriding objective and the allocation of resources, for example, it couldn't be that if you had an urgent matter that didn't have disputed facts, that you had another tier of appeals. this court well knows the struggle to get matters through the judicial system. And Guyana is no different, might even be a little worse. But if you add a court because your proceedings were in fact supposed to be urgent, and there was supposed to be no disputed facts in your matter, then you would have an FDA filed. The other side, presumably, one side would lose. They would then appeal to the full court. And then from the full court to the Court of Appeal, and then here. So you add a tier to the proceeding simply because you filed it by an FDA. That wouldn't be an appropriate in terms of the overriding objective about allocating resources in a proportionate manner and putting people on an equal footing, because you wouldn't be on an equal footing. So it would mean that if you really suffered an egregious harm and you have a pro note or a mortgage, for example, which is supposed to be security instruments that are very safe, then it would mean that you would have an extra court process to engage should you bring those proceedings by an FDA. It might be wiser for you to bring them by an SOC and thereby eliminate one tier of appeals. It also means that the court, the high court judges who sit in the full court, are going to be burdened by having to do all of the matters that are filed by FDA. All of those matters are going to have to go to the full court. So the high court will essentially become appellate judges. So it can't be that if you commence by FDA, you have to go to the full court.
Maybe it's good to look at the decision of this court in Chung, AIC Battery.
Yes, Your Honor.
Paragraph 20 said, undoubtedly Order 12 of the Guyana Rules of the Supreme Court was adopted from Order 14 of the English Rules of
Yes,
the
sir.
Supreme Court 1883. The purpose of that order was to enable a plaintiff to obtain summary judgment without trial if he can prove his claim clearly and if the defendant is unable to set up a bona fide defense or raise an issue against the claim which ought to be tried. So that goes to the possibility of getting a summary judgment.
Yes, Your Honor.
And now the rules also say summary judgment, that's 1502, summary judgment is not available when a proceeding was commenced by way of fixed date application,
Yes, Your Honor.
unless proceeding was ordered to proceed as if it was commenced by way of statement of claim. So
We've made it a little more complicated than we ought to, Your Honor, but if I may respectfully submit to the court that the position would be that the summary procedures under Order 12, you did not get to file a defense unless you demonstrated to the court that you had a defense which raised tribal issues. There is no equivalent
bona fide defense.
Yes, so you had to disclose tribal issues. There is no equivalent under an FDA SOC on our new CPR. Every claim that is filed, you file an FDA, you are mandated 4 days before the hearing. There are little different time limits, Your Honor, under the rules, but you have to put in your defense. If you file an SOC within 28 days, you must file your statement of defense. In the instance of an FDA, it's an affidavit of defense. But they're also filing an affidavit, and you have to respond. So there is no process whereby what is taking place is an assessment of whether you've got the metal or not. It is straight. You file it, a defense is filed. So that's a normal process. That's accepted in any system, any adversarial system in the Commonwealth. That's what it would be. But in summary proceedings, you filed the proceedings, and the court had the right to take away your ability to file a defense if you couldn't show them before you filed it that you had one. That is not a position that exists today, because our rules only provide two ways to start. One is by an FDA, second is by an SOC. And the rules provide very clearly how to defend an FDA and very clearly how to defend an SOC. You have strict time limits and you have to get your documents in. So that is a far cry from Order 12. So in the considerations that AIC would have correctly assessed on the Order 12 is that you had to raise a bona fide defense. Your Honor, that would in fact be true, because Order 12 required you to first meet if we should say, a pre-defense process, if you like, but that doesn't exist now. So you would really only get summary judgment if you apply for, if it would be, summary proceedings rather, if it would be under the summary judgment rule part 15 under the default, because you haven't complied with whatever rule that you should and you haven't put your papers in time.
So you are equating summary judgment with summary proceedings. Is that the effect of what you're doing?
Yes, Your Honor. For the purpose of the rules, because it wouldn't make sense any other way. I know that so much of the textbooks reflected differently, Your Honor. But I don't think that when we put summary proceedings in our act, that it could have applied to short, efficient disposal. Because if it was short, efficient disposal, Your Honor, then all the FDAs would have to go to the full court. And all the motions that have been filed in the last 50 years, at least, under the High Court rules, would have had to do that.
You see, Mr. Dattadine, you're taking an all or nothing approach.
I do realize, Your Honor.
Right. So your submission translates into, since pursuant to Rule 15, no summary judgment in an FDA, then no FDA. It's a simple syllogism, right? Then no FDA can be summary proceedings, because summary judgment, summary proceedings equate to summary proceedings, right?
Yes.
So in your landscape, there can never be a summary judgment in an FDA, right? Rule 15.
Yes, Your Honor.
And therefore, an FDA can never be a summary proceeding, right? Must follow.
Yes, Your Honor.
That's your logic.
There is still an unless, eh?
I do realize the weakness in the logic, Your Honor.
Unless the proceeding was ordered to proceed as if it was commenced by state.
An SOC.
Yeah.
Yes.
So it could still end up with a summary judgment.
Yes. If it was converted to an
But
SOC.
then 15.2.1 says, claimant may, after the defendant has delivered the defense, make an application for summary judgment on all or part of the claim in the statement of claim, depending probably on what the defense says. If it is an irrelevant defense, then the judge could decide to give a summary judgment, even though it started in the very first
Yes.
stages with an FDA. But you're saying, well, once it ends in a summary judgment, then that is a summary proceeding.
Yes, Your Honor. Or and I would fall back to the same position where I was struggling with defect. If it were a default, for example, you obtain the judgment by default because
There's no defense.
yes, but in those proceedings, the rules also provide that what you have to do is go back to the trial court as opposed to.
But in this case, didn't the trial judge, Justice Singh, effectively say there was no defense?
Your Honor, what he said is he accepts the evidence, but because of the existence of a statute.
As a question of law, there is no defense. The effect of the judgment is a very simple judgment. You have a transport, You raise a trust must be in writing, there is nothing in writing, therefore there is no defense. Isn't that a simple logic of the trial judge's judgment? Forget about whether we have a written judgment or not. Isn't that the logic that you all have brought before us? That's what your question is.
Yes, Your Honor.
Right, okay. So that essentially this is a case in which they brought a case, you mounted a defense, and they say, except it's not by pleadings, they say on the evidence,
Yes,
there
sir.
is no defense.
Right.
Now, it's an interesting question because could they have entered a summary judgment? Part 15 says no.
No.
Well, but what they could do under Part 8 was allow the application, dismiss it, or convert it, correct?
Correct.
And the judge allowed the application. Is that not right?
That's true.
So the task for us is to just determine what is or is not a summary proceeding. What I am not quite getting for myself is that when you equate summary judgment to summary proceeding, then what that means is as long as the matter is an FDA, it can never be a summary proceeding. Whether it is brought under statute or not, all of the categories that the Order 4, Rule 6 have included, right?
Yes, Your Honor.
Those would have been brought before by specially endorsed writ.
Yes.
And the whole purpose in the RSC in those matters was, these are matters which generally fell into the category of not largely disputed, right?
Indeed.
And you went through this specially endorsed writ in which you set out everything on the writ. There's no plea then, and you come to court. If there is a defense, then directions were given to have it contested. If not, the court heard the matter and gave the appropriate order, right?
Yes, Your Honor.
Would you call that a summary proceeding?
Under the Order 12, it would, Your Honor, but
Not under Order 12, under Order 6, under Section 6 of the Court of Appeal Act. In those actions brought by specially endorsed writ, the old Order 4 Rule 6 matters,
were summary proceedings.
where did they go? Didn't they go to the full court? In
Yes.
Guyana.
If the defense was struck out, Your Honor, then yes.
Yes, because they were considered summary proceedings. Why? Because basically there was, in the category you created, there was no defense. It didn't matter what was the nature of the claim, it was that there was no defense, there was nowhere to go. In other words,
Yes.
this was not a matter that was not summary. It was summary. It was dealt with in a summary in the magistrate's court. You elect to either hear matter
Yes.
summarily or
Indictably.
what does it mean when you elect to do it summarily? You have it here done now,
Right now,
and finished.
yes,
Now, the
yes.
system is not functioning as it should be. It takes too long. But really, that means what the CCJ described in the Chung case.
But, Your Honor, the reason why, respectfully, that the Chung case is restricted to Order 12 is because of the practice of what it is as it relates to, for example, motions, any motion filed. One side would put in an affidavit, the other side would put in the affidavit, the judge would make an interpretation which is based on law, an interpretation of law, and those appeals all went to the Court of Appeal. This court decided in Robin Singh, and this court decided in let's just stick to the name I remember, but in Robin Singh and GCB, that even though it was an ex parte application made to a judge that was refused, it went to the Court of Appeal. So, Your Honor, respectfully, AIC battery could really only be restricted to Order 12, where you commenced summary proceedings by a specific rule. But we have no way of commencing summary proceedings anymore.
But in Chung, did they not come by a statement of case and in the existing matter take out Order 14 summons?
No, Your Honor, they filed a specially endorsed writ.
The specially endorsed writ?
Yes. In our specially endorsed writ, Your Honor, essentially in the old writs, we used to have, where you have an endorsement to claim, a specially endorsed writ doesn't have an endorsement, it has a statement to claim.
Yeah, I'm aware of that,
So
right.
there's sometimes a bit of confusion, but that's in fact the endorsement of the writ. And that's how it proceeds. So it can't be that if you consider it all and you decide that on the affidavits, this rule of law is what I will apply, that would be like a constitutional motion or any motion that had been filed, and those appeals went to the court because it was determined on the merits. The only time that the Order 12 applied is when you were prevented from putting in your defense. If you were allowed to put in your defense, the appeal lay to the Court of Appeal.
Would you say summary proceedings would include the category of matters that are uncontested or uncontestable? In other words, Order 14 is a category of that. But
Yes.
What you use the word defects, but as I listen to you, what I hear coming out more and more is matters that are uncontested or uncontestable.
Your Honor, I'm not, the uncontestable part, respectfully, Your Honor.
If you have no defense,
But again,
no defense.
Because the issue would be this, that as long as you have put in your defense, whether it be by affidavit or a statement of defense, then your defense is there. And if the court finds that your defense holds no metal and is not worthy, then the plaintiff or the claimant will win. But if we take it to the part of it being uncontestable, respectfully, it might become very difficult to discern which one it was. And
So in a striking out application, is that summary?
yes, Your Honor, and there's,
But in a striking out, you're striking out the defense and entering judgment.
yes, Your Honor,
The defense filed,
yes,
move to strike it out because it's frivolous, vexatious, or whatever else.
yes, Your Honor,
It's struck out. You conceded that that was a summary proceeding.
I do, Your
Told
Honor,
us that summary applications to strike was summary.
yes, Your Honor.
But in summary, there is a defense filed, there is a contest, but it's struck out and judgment is entered. So why are you resisting in, you gave that as an example.
But Your Honor, if I could say this one's given me so much trouble, Your Honor, but respectfully, because we haven't made it easy by introducing things that are, and not amending when we should not, but in simple terms, Your Honor, the striking out, respectfully, I reasoned it this way, and I regret if I might be incorrect, but I reasoned it came down almost to the situation of an Order 12, where you were not allowed to put in your defense, as it were, because you put it in, and the other side has come and said, look, this is not worthy of a defense, and we should strike it out. So instead of it happening at the front end, where you had to get the judge's permission to show you had a defense, you have shown your defense, and the other side is coming at afterward, at the back end of it, to say, look, it doesn't have any. So
And you consider that to be summary proceedings.
I do, Your Honor, and that's how I got there.
And on the facts of this case, use that analogy.
Yes, Your Honor.
On the facts of this case, they put in their case, you put in your defense, your affidavit,
Yes.
and the judge struck out your defense.
Well, he didn't accept that what we had disclosed, what we had done. But, Your Honor, in our appeal, we said he should have taken evidence too. There are other issues in this. For example, that the deed in these proceedings is a lease. And if you look at the Immovable Property Act, you can't move the court to divide a lease. So there was another issue other than that was a matter, but that's the full part of it and not this discussion. But, Your Honor, if you're to take it to the position where FDAs go to the full court, then we're adding a tier. So we have to have some way of what to look for. And the respectful line that I would suggest is if there was a determination on the merits, which has always been the practice as with motions filed in company constitutional public law. In the old days, it was affidavit evidence. So if it's the determination on the merits, it goes to the Court of Appeal. If there is no determination on the merits for whatever reason, it goes to the full court.
That's how you define that.
That's how I would, but
If, so determination on the merits
yes, Your Honor.
is what will, or not, will determine what you mean by summary proceedings or not.
Yes, Your Honor. If there was none on the merits, then that would be where we would have, for some reason, it's struck out, it's, there's a default, it's, whatever. If there was no determination on the merits, then the full court is where you would have to go.
I think we follow you, Mr. Dattadin, and I don't know about your time, but
There were,
you want to say anything more to this?
just to emphasize one point that I had said, I touched on earlier, about the overriding objective. I know that that's usually the fallback position for nearly every argument that involves the civil procedure rules. But, Your Honor, save and expense is one of the things that the court should consider. Dealing with cases expeditiously is another. This is all 101 of our civil procedure rules, and 101E also is to allocate resources in a proportionate way. Now, the overriding objective must be taken into account in interpreting the rules and what we do. So I would respectfully say, Your Honor, save and expense is not achieved by having one more court. The lawyers get paid one more time. The expense and time involved by having one more tier. The same is true, Your Honor, if you were to consider allocation of resources. High court judges are going to be hearing the first one and the second one. And one would hear the first time when it's filed, when the first hearing, and the second occasion it would be two. So you're going to take high court judges out of doing what high court judges ought properly to be doing. And that introduced, the CPR introduced new powers that the court had to manage and move things along, including, I mean, at a case management conference, the court could strike you out then too. So there are ways and there are mechanisms for where the matter would not reach essentially to that stage. So respectfully, Your Honor, I might have taken a little bit more. I know my friend, yeah, he likes to speak more than I do, so he might be longer. But that would be all, Your Honor.
Okay,
Thank you.
thank you very much. Mr. Nanda,
Thank you very much.
and I'm sure
Thank
you're
you
not
very
going to
much, Your
talk
Honor.
longer than Mr. Dattadin.
No, Your Honors, and I want to congratulate the court for the patience displayed this morning. Your Honors, a convenient place to begin is first of all to express my humble concurrence with the sentiments expressed by Your Honor, the President of the Court, in expressing the view that a very clear and uncomplicated issue has been made complicated unnecessarily. Your Honors, firstly, in Guyana, we already have a ruling from the full court in a case in which my chambers appeared, in which the full court accepted that the full court is the proper forum for appeals emanating from fixed date applications. And that decision is over a year old. Secondly,
Do we have,
in the
do we have that
decision-
decision, Mr. Nanwell?
Un-
Is that part of the record?
Unfortunately, Your Honor, there is not a written decision delivered as yet.
Oh,
Secondly, we have the ruling from the court below in this matter, the Court of Appeal in this matter, in which the Court of Appeal has said that it is not the appropriate forum for appeals emanating out of a fixed date application. And then we have the practice direction, to which my learned friend referred, which I have uploaded this morning belatedly, and I apologize, in which the bar engineered that those practice directions through a collaboration, of course, with the judiciary. And in that practice direction, the intent was to transport as a collective all the order 12 matters, what we calling the specially endorsed writ matters, and put them over as fixed date applications. To add, and the practice direction itself says, it's to add to what Rule 8:012 says must be commenced by a fixed date application. I say that, Your Honors, to assure the court that in the profession, perhaps there was doubt initially, but those doubts have largely been dissipated. And the current practice being ensconced is that fixed date applications or rulings emanating from fixed date applications are now being filed as a matter of course to the full court, and rulings coming out of applications other than fixed date, statement of claim, etc., they go to the Court of Appeal. So I want to make
So
that
just a minute,
point.
so are constitutional motions ever brought by fixed date application?
I'm going to get to that, Your Honor.
All right, yeah.
Now, prior to the CPR, constitutional motion, if Your Honors will remember the case of John Doe and the Attorney General, in the 70s, at that time we were still annexed to the Privy Council in Guyana. In John Doe, the issue arose, there were no rules prescribing how to approach the court in constitutional motion. The lawyer in John Doe, I believe, because of the fact that he was going under a written instrument, commenced those proceedings by originating summons. The matter went all the way to the CCJ, to the Privy Council, on the question of procedure. And Lord Diplock, in terms of that point, said, made short trips of it, said that, it matters not what procedural vehicle is utilized. The fact is that the legislators, the making authority, did not prescribe any rule at the time, and therefore they accepted the originating summons. Coming out of that, we passed in Guyana a Fundamental Rights and Procedure Act, Chapter 302 Laws of Guyana. And in that act, we prescribed the procedure for governing constitutional motions. Learned friends spoke at length, so that's how constitutional motions were largely governed. They determined in the High Court, and they go straight to the Court of Appeal. Then we had in Guyana for a number of years until 2014, I think, the Judicial Review Act. Before that, we were governed by the Crown Office rules. 1905 out of England. We have a number of cases debating the procedure and so on. So that was what largely governed public law proceedings. There were writs of certiorari and the ancient writ of mandamus, etc., etc. Robin Singh came out of that procedural vortex, and it's a very complicated decision. And the court will have to read that case carefully, because it was the first time that such an issue arose in nearly 100 years in practice in Guyana. And it had to do with the absence of certain procedural safeguard within our rules, because Crown Office rules were never received. We were following the Crown Office procedure. So that case is quite complicated and should be looked at, and the judges in that matter, the CCJ, and quite asked to merge the existing rule network at the time, that was pre-CPR, and the absence of the Crown Office rules or any rules governing prerogative writs in Guyana. So I ask respectfully that the court be wary of that case and look at it very carefully. It's a case that stands on its own and would hardly give guidance in relation to other matters. Now, the other matter that I want to raise respectfully is to examine how these procedures, or rather how an applicant used to approach the court to seek remedy under the statute that this applicant used. That is the sale of the Immovable Property Sale of Interest Act. Now, for the past 40 or 50 years, the procedure utilized was by way of originating summons. And the originating summons was always appealable to the full court, simply because of it usually is heard and determined in chambers, and at that time, physical determination of the case meant something or had greater significance than it bears now, and it was decided largely on affidavit. In fact, I would dare say that originating summons that were heard and determined in open court, so to speak, where there was a full-blown trial, the appeal went straight to the Court of Appeal. But once a judge sat in chambers and disposed of an originating summons, and it is in the old dispensation, it used to be dealt with under Order 43 in the 1955 rules, then the appeal naturally lay to the full court. Now, we have the situation here where you have summary proceedings being used in our Code of Appeal Act. And it is nothing new. That Code of Appeal Act has been there since 1959. The 1955 rules makes no reference to summary proceedings. There is no definition either in the High Court Act, in the High Court rules at that time, or the Code of Appeal rules of what summary proceedings were. Therefore, the judges over the past 64 years had to categorize different types of approaches to the court into summary and non-summary for the purpose of determining which appeal court to use. I say that to say that what we are engaging here, or what Mr. Dattadin wants to create as a new task, is nothing new. Our judges over the past 65 years, without any guidance from the rules, have been determining, looking at the type of cases, looking at the type of approach, looking at the type of disposal or the manner of disposal, they used to determine what are cases appealable to the full court and what are appealable to the Court of Appeal in the same context of the rules of existing legislation. And out of that, out of the experience to which we can make reference, 64 years of experience, all specially endorsed writs went that way, went to the full court, all matters that were summary. And we don't have to invent the wheel as to what summary is. That the Sousa dictionary, the dictionary out of India, a copy which I have, has a most, and when I first was dealing with this issue of summary, not in these proceedings, but in another proceedings a few years ago, I checked every available law dictionary, Stroud's, Black's, and all of them. And none of them had a more elaborate description or definition of summary proceedings than Sousa. It's a book out of Goa, hence the Portuguese name is Sousa. And that is the basis of the decision in Cham, because we couldn't find another description. So, and it is not only confined, though largely over the years it was confined, or all the specially endorsed writ because of their close resemblance to all 14 matters at that time in England, they were all generally categorized as summary. But there were other matters, obviously, that were dealt with as summary matters. And among them would have been matters where there is no evidence. What does summary mean? Your Honours, at this stage of the legal profession, with the evolution of law, we can't be debating what summary means. I want to take my hat off to the Honourable Justice Javen, who made so many efforts to explain. But it's not necessary. Summary means short, swift way of disposal without going to the common law way of trial. It means nobody going in the witness box. There is no long address to jury, or there is no jury here. That is what non-summary, that's what summary means, the absence of those things. So any matter determined without resort to those procedural forays would necessarily fall into the category of summary. And the judge in this matter sat in chambers. Well, I don't even want to say chambers because the judge indeed sat in chambers. And the rule says chamber, or in this case the judge satisfied both requirements because he actually sat in chambers. And for practice in Guyana, there are judges who hear fixed date application in open court as well. So this judge sat in chambers, looked at the affidavits. Mr. Rafudeen raised legal submissions. He raised them in the affidavits. I think he oralized them before the court. The judge rejected them, and the judge granted judgment. But I don't know what other way you will describe that other than summary. And the Court of Appeal Act says, summary proceedings, you appeal there. So, Your Honor, this matter is very, very uncomplicated, and it has, in my view, already been settled in Guyana, and I don't think that we should expend any great amount of energy in, except, Your Honors, I plead that the court should write, because I suppose Mr. Rafudeen is not, I don't want to think that he's the solitary lawyer holding views that he so passionately and emphatically expressed to the court. There may be a minority of lawyers following that viewpoint. So this being the highest court, I invite this court to bring some clarity with a judgment. Your Honors, before I close, and I'm not going to be very long. I don't think it's necessary for me to be long. There is two issues that I would like to quickly address. One is that the rubric of this matter has the name Rafudeen Nizamudin. But in the High Court, we are the applicants, so we originated the proceedings, we constituted the parties. So he was not a party. A notice of application was filed to make him a party. That notice of application was refused, and he was not joined as a party, and he had a different lawyer at the time. And unfortunately, he appeared back in the Court of Appeal. When the appeal was filed, his name was added as a party. And unfortunately, the way the matter was disposed in the Court of Appeal, also almost in a summary way, I believe that, I know that the point was not taken. So this gentleman is not a party to the proceedings.
Is that matter disputed? Is that a disputed matter, or is that accepted? Is it accepted that this is an error on the record?
But Mr. Daxton will have to answer that. But I'll proceed, but an examination of the record will show that that he was struck out on the 12th day of June, the application to join him was refused, 12th day of June 2019. And the other point is, I want to raise, Mr. Dattinen, I just want to draw attention to his submission before the court. And his recitation of fact. He says in paragraph 1, submission is at page 216 to 27 of the record. Paragraph 1, the first applicant is an adult and a joint owner of property held by deed of transport. So I heard him say just now about lease. I just want to draw attention to the fact that he himself says on the record it is a transport. But that issue of whether lease or transport has not been raised anywhere in the proceedings. Your Honors, if there is anything, I also want to, I have Colini here for whatever it is worth. It's a useful text. And Your Honors, at page 11, Colini examined the rules in the region, and they are all a few differences. They all carry the same form, and I think they have the same policy. And our part 8 is not much different, with the addition of the practice direction, is not much different from the other jurisdiction. And in those jurisdictions, fixed date applications are used under their rules for proceedings exactly like this one, where an enactment, whereby any enactment proceedings are required to be commenced by originating summons or motion, meaning application filed for statutory prescribed or offered remedies. So, Your Honor, throughout the Caribbean, these types of proceedings, the one that we have filed that used to be done by originating summons, are now done by fixed date application. Throughout the Caribbean, I would not want Your Honor Guyana to stand out, and this application should be treated differently. And fixed date applications, as the court is well aware, can be determined on the very first day. On our rules, it is the same thing. And there is a point that I don't, on this 2 points more I want to raise, as I'm talking, they're coming to me. Mr. Dattinen keep emphasizing that summary disposal of a matter results in 3 layers or 3 tiers of appeal. And that is so, but that has been so in Guyana since 1955. Because since 1955, summary proceedings were appealed to the full court, and from the full court it went to the Court of Appeal, and when we didn't have a final court after that for a while, but when the CCJ became our final court, it was 3 tiers. And statement of claim matters, unfortunately, had only the Court of Appeal and the CCJ. That is the reality. Nothing in these rules brought about that. So, Your Honors, I'm not going to change anything. That is how the practice unfolded. Neither myself nor Rafudeen. Mr. Rafudeen are responsible for it. This is how it is. If you have an appeal to the full court decisions are appealable to the Court of Appeal, and the Court of Appeal decisions are appealable to the CCJ. So there's nothing groundbreaking about it. That has always been the position in Guyana. The other point that Mr. Dattinen, that I think
when were appeals, when were appeals to the Privy Council abolished? When was the Court of Appeal the last?
1970.
19?
With the Republican
1970.
1970.
Yeah.
With the Republican Constitution. We had 1966 to 1970, we had the Independence Constitution. Then you had the Republican Constitution in 1970. That lasted until 1980, when we had the infamous Executive President Constitution. But Your Honor, Mr. Dattinen has a concept that I think he thinks is wrong, because he keeps saying that a summary matter is not a determination of a case on its merits. But that is a concept that is not necessarily correct. A summary matter, once it's heard in the way prescribed for it to be heard, and it is concluded, it is a determination of the matter on its merits. It's not a default judgment. Both sides are heard. It's just that one side's affidavit, defense, or whatever is rejected in a summary way. But that doesn't take away from the fact that it is a determination of the case on its merits. And, Your Honor, Part 8:04, Rule 5 says this: at the hearing of a fixed date application, the court must A, proceed to determine the application based on the evidence before it, or if there is insufficient evidence, to determine the application on its merits. So right there, the court has the power to determine the application on its merits. So I just thought that I would put my view forward that it is not, in my view, respectfully correct that a summary disposal of a matter excludes the possibility of that matter being determined on its merits. There are situations where it is not determined on its merit in a summary way, but there are situations where a summary disposal embraces also the disposal of the case on its merits. Your Honor, if there is nothing else I can assist the court with, that would be the extent of my humble presentation.
Thank you very much, Mr. Nandlal. As I understand it, the applicant or applicants, we will hear Mr. Rafudeen about that point, about the second one. They appealed in time, but in your view, and also in the view of the Court of Appeal, they appealed to the wrong forum. Correct? Mr. Nandlal?
Yes, sir. Yes, sir.
Okay. So then the question is, suppose we would agree with you, would there be any objection if this court then directs the full court to hear this appeal? Because then the appeal should have gone to them. Is there any objection against such a direction, as far as you concerned?
Yes, sir, I would object because please don't interpret this the wrong way. The full court is the master of its own procedure, and the full court should be allowed to hear a determination of an application for an extension of time.
Okay, clear.
In the appeal. I believe that this court would be respectfully unduly interfering with the full court's exercise of its discretion on whether or not it should hear the appeal.
Okay, that's a clear point. That's why I raised it, so that we could get your view on that.
Thank you very much, sir.
Mr. Rafudeen.
Your Honor, if we start with the simple ones first. Mr. Nizamudin, who filed an NOA to intervene, was then allowed to file an affidavit of his evidence, and he was then allowed to make submissions as to whether or not the proceedings were on the same issue of the trust, of whether the rule in Boosted removed all of the applications of the statute of fraud, and he did do so. And there is on the record, there is record that he filed his NOA. There's a record that he was then instructed to give submissions on the merits. What is not written on the court's file, Your Honor, is that he was admitted into the proceedings. But we respectfully believe that that's an oversight. He did file in the notice of appeal that was before the Court of Appeal. We didn't receive an objection of any sort from the respondents. They did not raise it, and the Court of Appeal determined it with him as a party. So, as it relates to that, Your Honor, we respectfully say that he is a party.
So can I just ask, we were told that he filed a notice of application and it was refused on the 12th of June 2019. Is that correct?
Your Honor, what the court did on the 12th of June was made the ruling that it did. That's the first decision that the court made. Well, the decision to bring the matter to an end, to say that as a result of the statute of frauds. We have complained and we have mentioned the court continued to make order even though the Court of Appeal was seized with it. That's a whole other issue. a case, and if, should I turn off the phone? Okay. And I think he did. And if there is such a circumstance, you can make the application to strike. There are a plethora of things that a judge can do now because of over the proceedings. So respectfully, Your Honor, those parts for which would have to exist. The part that we wish to emphasize to the court is it is unhelpful because of the practice that is in Guyana to use the parameters about no formalities of a Guyana experience, because we have been going on with proceedings that are on affidavit and appealing things. If we take what the text, especially the English text, saying about by summary proceedings, we do ourselves no favors by taking that and trying to import it. Respectfully, Your Honors, thank you.
Leave. You have asked to treat it as the appeal itself. That would, of course, get us to quicker to the result. We will consider all the arguments. We also take into consideration that if we can, in our consideration, come to the conclusion that we could deal with this as the appeal itself, then we will do so. We will also, of course, think of the other important things as any broader definition or any broader interpretation will have all kind of consequences for
Forever grateful to that, Your Honor.
However, that might also be the fact that we are only 3 might be a reason then not to go that far. So there are all kind of possibilities.
Yes.
We are not yet in a stage that we can say that is the direction we are going. We will carefully consider all the arguments, also from Mr. Nandlal, of course, and will, as soon as possible, give you some form of...
Your Honor, if you may permit me, my colleagues who I play cricket with in Trinidad have been trying to scare me for the past 2 weeks about appearing before Justice Jamadar, and I think they were really just trying to scare me. It was indeed a pleasure, but we'll find out just how much of a pleasure when the decision comes out. But they were really scaring me as to what to expect. It turns out that...
Mr. Nallal, you're saying something?
Yes, please. There's one last point that I really feel compelled to speak on with your leave, and it is to draw the court's attention to part 56 of our CPR that provides for all judicial review, constitutional matters, and a whole host of other matters to be dealt with under the Judicial Review Act, and that act confers the right of appeal to the Court of Appeal. So that is why, Your Honor, the Christopher Ram, the no confidence cases, they reach to the Court of Appeal not by virtue of these rules, but by virtue of the Judicial Review Act that allows for all public law matters to go directly to the Court of Appeal from a first instance court. So I thought that the point I want to make, Your Honor, is that the full court is not going to be overwhelmed there are other mechanisms that divert matters away from the full court.
Thank you.
The Act, for example, has its own regime.
Thank you, Mr. Nunwell. That's, of course, a point we have to consider. And that's why I was somewhat cautious in saying in what direction we might want to decide this matter because of, further consequences. Clearly, everybody wants to have clarity, but we need to go through this very carefully before we can come to a definite decision. So thank you.
I'm uploading the Judicial Review Act, Section 22, deals with right of appeal.
Okay, we take note of that, and we will give a decision as soon as possible.
Thank you very much, Your Honor.
All right.